So, good morning, everyone. I want to bring you up to date on a critical development at the State House on land contracts. Right now, if you write a land contract for an investor, as an investor, you're acting as the bank, right, to a buyer who isn't qualified to get a bank loan to purchase your home. So, what happens under current law is that if you are a seller, you can evict, so to speak, a defaulting land contract buyer just like a tenant under a forfeiture provision if they have less than 20% equity in the property. That's sort of a general rule of thumb that I want to give you. That's what the law is today. So if a buyer comes in, it's a $100,000 house, they put 5 grand down, they default later, right? That's to protect the seller from this kind of a default. So if they have paid, though, 20% down, then you have to foreclose on them. And it's a little bit murky in the case law and in the courts themselves how readily that 20% is calculated and what evidence is needed. But nevertheless, I don't want to go into all that kind of calculation. What's happening right this minute is a bill in front of our Indiana legislature. It's number House Bill 1495. It also recently passed the House of Representatives, and they're going to lower, under this bill, lower the down payment or lower the equity requirement for foreclosure from 20%, the current law, down to just 5%, literally 5%. That's stunning, right? So that's more like treating these land contract buyers as if they have a mortgage with the bank and like an FHA loan that only's got 3.5% down, and they still have to be foreclosed on to get them out, right? 5% for a private owner selling to a fairly unqualified buyer because they can't get bank financing is a substantial change in the law. I put the title of this as Lions and Tigers and Bears, oh my, right, from Wizard of Oz. Like, holy cow, this is huge and dramatic. So we're following it. Indiana State RE is following it. We're trying to jump on this right away, but it's going to have, if it passes, it's going to have seismic changes to the thousands upon thousands of land contracts that are out there. A lot of them have language in there that say 20%. Some of them have up to, I've seen 40%, right? When I see those, I tell sellers probably you can get a fly, but you can put it in there and see what the court does when you're foreclosing on these buyers. But it's a very big change in the law, but it goes along with this idea that abusive practices are going to be addressed by the courts and the legislators. And if we don't speak up, they just think, oh, poor buyer, they're losing their house, they're losing their $5,000 down payment without a foreclosure opportunity. But guess what? They're not qualified. That's why they've got a land contract instead of something else. That's why they're paying a higher interest rate than a bank loan, because they do not qualify for a bank loan. Go get one if you can, right? That's where there's a lack of balance in the conversation sometimes, and why, as representatives of landlords and real estate investors, we like to jump in there and do everything we can for you. So watch that bill, House Bill 1495. We'll keep you updated on it, but also we'll give you some more info on what this 20% means on land contracts. But send this to everybody you know. It's a very big change, and it's financially dramatic for every land contract seller out there. And you maybe will get grandfathered in for your old contracts. I don't know. That may be an amendment that needs to be added. But we just saw this in the Indiana Lawyer yesterday. It came out, so I wanted to let you know what was happening. We'll keep you posted. Send this around to all your investor friends. Keep them updated. Thank you.